So if you've been in a car accident recently and you hop on the phone with the insurance adjuster and they give you this really sweet, kind, gentle voice, hit pause. I've been helping folks in South Carolina for over 15 years deal with these companies. And here's what I've learned. In this video today, I'm gonna break down 11 of the most common kind of sneaky tricks that the insurance companies are gonna play on you in trying to either devalue your case or deny your claim altogether. The first thing the insurance company is going to do, or one of the main things they're going to try to do, is rush you through the process. I believe there's two reasons why they're doing this. The first is they are trying to get you to settle the case before you know what exactly is going on. They want to give you an offer that seems in the moment very reasonable in hopes that you will resolve the case, they can close the file, and you won't ever talk to a lawyer. That comes in the form of we're going to cover your medical bills and pay you $500 or $1,000 for pain and suffering. And they couch this in the way of, isn't that reasonable? Don't you think that's the reasonable thing to do? The second thing they're going to do is be very, very nice. All right? They're going to play into, for the most part, their first move is to play into, they're a good neighbor, you're in good hands. They're gonna play that hand of being nice and being reasonable, or they're gonna sound like they're being reasonable, but they're not actually going to be reasonable. They're just going to be nice and sweet to try to get you into the mode of then rushing through your story, rushing through your case, rushing through your resolution, and rushing through the investigation and your treatment that you would normally get if you had pushed pause in that communication with you. The third thing they're going to do is they're going to partially blame you. All right, so they're partially going to blame the person who on the accident report that you're looking at from the police officer doesn't blame you, doesn't put you at all at fault, but the insurance adjuster is going to try to assign 5% or 10% or 20% of the fault to you. And what that means is that, number one, it's going to tick you off. And number two is they're going to say, well, your case is worth, we would normally pay you $10,000 for a case like this, but because you are 30% at fault for the wreck, we're only going to offer you $7,000. And so that is a tricky way, and a way that you can't disprove. Once the adjuster kind of figures out that's what they're going to do, they're going to stick to that 30%. And so now you're stuck at negotiating off some reduced amount of medical bills, pain and suffering, lost wages, and all the things that you're going to be trying to get from them. The fourth thing they're going to do is they're going to try to get you to sign a HIPAA release form. Now remember, this is all coming from that nice, polite, courteous person and very reasonable person, saying that the reasonable thing for them to do is to be able to get some medical records for you, get the information they need to really evaluate your case. But you don't want to give them a carte blanche, a blank check to go back and find medical records from 3 or 4 or 5 or 6 years ago. You don't want to give them the ability to kind of dig if they don't need to. And so do not sign a HIPAA form. The fifth thing they're going to do is they're going to try to blame some of your pain and your injuries on pre-existing problems. So let's say that you've had a back problem for the last 5 or 10 years, but it's been managed with Advil and rest, and most of the time it doesn't rear its ugly head. Maybe once in a while you work hard in the front yard and it bothers you the next day. But after the crash, you can't get out of bed. It's the same location of the pain, but Advil and rest no longer tamp it down. Well, they're going to use that pre-existing condition, or try to use that against you to minimize the value of your case. This is one of the big tricks they're going to play, and it's going to be an important part of their arsenal. But that couples with, do not give them a HIPAA form to allow them to go back and plow through your medical records from the past. The sixth thing they're going to do is, I've talked about this before, but they're going to throw around this reasonable and customary jargon about your treatment. And so even though the physical therapist said you needed 36 visits and your orthopedic surgeon said you needed to go to the physical therapist for 36 appointments, they're going to say that people in wrecks like yours only typically need to go to 24. And so they're going to cut that bill off at 24 and then leave those other bills just hanging off behind you for you to deal with later. The seventh thing they're going to do is they're going to ask you for a recorded statement. And again, this is going to be couched in that polite, sweet, understanding, courteous voice of this is the reasonable thing to do, don't you think it should be reasonable that I could get a recorded statement from you? And the answer to that is no, it's not reasonable, especially not right after the crash, right? I don't think it's ever reasonable, but you never want to give a recorded statement, and you definitely don't want to give one right after the crash. Number 8, this is a kind of a parallel to the HIPAA form. So if you say, I'm not going to give you a HIPAA form, they're going to ask for past medical bills, and it's going to feel very onerous. They're going to say, like, I need 5 years of previous medical bills. It's going to feel very onerous. A lot of times it's not even in a pre-existing condition situation. They're just asking for more stuff to make you fight longer, to probably give up. If they haven't been able to get you in a rush to settle quickly, they're going to try to draw this thing out for as long as possible to force you to take less money. At some point in time, you're just going to get tired of waiting, tired of doing what they say, and force you to take some crappy offer that they make to you. The 9th thing that they do is they're going to point to your car or point to the defendant's car and say, there's just not a lot of damage here, so why should we pay you for X, Y, or Z injuries that you've suffered? We know that the damage to the car may be indicative of the injuries in the car, right? But like, it doesn't mean that because the car is sandwiched like a aluminum can, it doesn't mean that the person didn't walk out of the car, walk away from the crash. No more than it's likely that there is no damage or very little damage to the exterior of the car means that the person inside the car couldn't get hurt. We've helped folks, countless numbers of folks, that the exterior of the car has very little to minimal damage, but the person inside the car suffered some serious consequences. The 10th thing these folks do is make what would seem to be a very reasonable offer of just a little bit less than your medical bills, but then tamp on this $2,000 or $3,000 pain and suffering payment. But they do this because they know that your health insurance is going to cover or has already covered a substantial amount of your medical bills, so that you're really only out of pocket maybe $500 or $2,000, right? And you also have $15,000 or $20,000 of medical bills. They know that if they make you an offer of $20,000 medical bills plus $1,000, that's $21,000, of which you're going to walk away with potentially $20,000, because they know that your health insurance is already covered only up to $1,000 or $2,000, which is the only thing you have to pay back. When in reality, they should be paying a substantially more money than that $21,000. And so that is one of those little tricks that feels reasonable on its face, but based on the law is not reasonable whatsoever. And piggybacking on that, the 11th and last thing that they will do is they will conceal or outright lie about what the law actually is, or what the law is in the situation. And going back to that example a second ago, they're not going to tell you that if you have $20,000 in medical bills, a jury in this county would typically award you, 40 or 45 or 50 or 60, whatever those normal results may be for each individual county. They're not going to tell you that. They're just going to make their offer seem very reasonable. And on its face, it does seem like it should be that way, right? If you're going to pocket $20,000 for your crash, it seems like it would be awesome. But if they were actually a good neighbor, or you were actually in good hands with them, they would offer you 40 or 42. That's a lot more money. That's double the money they were going to offer you before, and it's what probably is actually reasonable in that situation. Don't let their lies or their omissions about what the law is or what their requirements are to do to kind of cloud your ability to figure out what you should or should not do. So if you've been in an accident, be on the lookout for these little sneaky tricks that the insurance companies are going to play. And if you know someone that's been in an accident and they're starting to deal with the insurance company, send them this video so you can help them along the way.